Thank you for everyone for coming. And I appreciate everyone spending their time and doing this with us today. So today is kind of a mix of different topics. We have a few different ones to go over. They're often topics that aren't talked about very often in seminars and things like that, but are pretty large considerations when you're trying to set up your estate plan. And so we're kind of highlighting just a few of them. And so today we have speaking as myself. I'm Amber. I'm one of the attorneys at the firm. Then we also have Michael and Ryan. Those are the other two attorneys in the back. Some of you guys may have seen them, worked with them. They're all great. We have our amazing admin staff as well. So if anyone has questions or needs anything, generally you're talking to them. And so with that, I like to start off with the topics we're going to be covering. So it's going to be a few different things. We're going to go over the pet trust and what that means, if anyone's ever heard of it, all of that. Then we're going to go over the Secure Act, because that's ever-changing and a pain in everyone's butt. And then we have the real-world considerations, the marriages, the divorce, the mixed families, all these different factors when it comes to your estate planning. That's we're going to kind of roughly talk about that. Do I need to factor in something for my beneficiary who I trust, but maybe not 100%, maybe they've abused some drugs or alcohol, things like that. And then ultimately divorce. And how does that affect your estate planning? Because often we have to work with your divorce decree, not against it. So with that I'm going to start off with the pet trust. Has anyone ever heard of a pet trust? Yes. Does anyone know what a pet trust is? Kind of. Okay. So generally, a pet trust is a trust that you have for your pet. It's pretty self-explanatory in that regard. It's set up so you can fund it with money to help care for the pet and for the person who is the caregiver of the pet to be able to take care of them. What are the guidelines? Are there specific medications that only you as the owner would know about? These things would all be encompassed in that trust. And so it's strictly for the pet. So whether it's a dog or a cat or a tortoise, we have birds that live longer than us. We have to factor that in there. So with that, I personally have a little fur baby. His name's Morty. And so if something were to happen to me, I, of course, would want anything and everything to be taken care of for him. He is my little prince. Love him. And so with that, I would figure out who's going to be the caregiver, who's going to be the backup caregiver, because we always need to plan for alternates. We need to plan, what if something happens to them? We're planning for what if something happens to you. So we got to think laterally with that. So there's different roles when it comes to a pet trust. There is the owner, the person who creates it, the trustor, you often hear that. And that's the person that dictates how and what the document says. How much money is going to go into the trust? What are the guidelines? Who has final say about doctor's appointments, vets, all of that fun stuff? Who has that say? Where is it going to live? Is it supposed to maintain a certain lifestyle? Have you made him very comfortable and make homemade meals for him every week? That's a very different lifestyle than just having some hard kibble. So it's factoring in those different things. And with a pet trust, you can do that. You can require someone to abide by your guidelines. And so if you want those everyday homemade meals, then you have to be able to definitely compensate the person, the caregiver, who's handling that and doing that for you. So with that is a portion of the money would go into the pet trust. That is for their medical needs, supplies, housing, all of that is strictly for the pet. No one else. It is not for the caregiver. It's not for the trustee. No one outside of the pet. So this can be changed. Often we have this written in documents at our passing, because generally if we are alive, we don't want to give them up. However, if something does happen and while we are alive, things do start to fiddle down and we're not able to take care of them the way we used to, then a pet trust is another great option. But if you say, hey, I just want my pet to go to this person, I trust them, take care of it completely, I don't have any questions or concerns, then you can just give the pet in your will or in your personal effects and things like that to be able to just hand off the pet to them. But with that, that does not mean that they will not have money to take care of the pet, so it would be out of their own pocket. And also they would have all final says, and it is their animal now, no longer part of the trust. And so there are different factors, and you really want to think about how much control and how important it is to you to keep and maintain the lifestyle they live. Which sounds crazy, because it could be just a bird or anything like that, but trust me, I would do anything for this dog, anything. And so if that meant setting up a pet trust at some point, odds are it's gonna happen. And so with that, there are different roles. We have the trustee. That's the person who manages the money. That's the person who manages the trust, says when things are okay and when not, and then we have the caregiver. Sometimes they're the same people, and it's all great. They manage the money and the trust. Sometimes they're not. Sometimes it's like, hey, I trust you to take care of my animal because I know you're gonna do the best job possible. However, you're awful with money, so I can't trust you to do that part. And so with that, we go ahead and we have someone else be the trustee. It's really just the manager to double check, make sure they're doing everything right. But often, if we're giving our pet to someone to take care of, they often can handle that as well. Now, do we have any questions in regards to pet trusts and what that would look like in regards to our pets? Because, for example, tortoises, birds, these all live longer than us. So when creating it, you do need to factor in its time, like its lifespan. So if it still has another 50 years, you're going to create this pet trust. Let's think about, okay, 50 years of funds. What does that look like? And you'd be surprised. People put in a lot of money towards their pets. And so with that, we want to make sure that they're well taken care of and they're not holes at the end of the day. Yes?
How long has this pet trust system been up and running?
Ooh, pet trusts have been around for a very, very long time. I'm not sure the exact date. It's been around for a very long time because when I was in law school, we read a case from it back from, I think, 1960s. So it has been around for a while. That case was actually really interesting. It was all about $1 million cat. And the pet trust was set up for them to make sure it was managed and taken care of for that cat. And it was. They did a great job for it. But with that, we want to make sure that it's an option. It's not necessary. Often these things come up, and if there is nothing that in your will or your documents that says who's going to take this animal, and no one steps up, then often they end up going to the shelter and things like that. So just planning, because during that transition, they've also lost you, and that's a huge heartbreak for an animal as well. And so a lot of people don't think about that. That is a struggle, that's a transition that they have to go through. So you want it to go to someone who can take care of them and not just be a temporary home. So it's important to think about all those different factors when thinking about a pet trust. Do we have any other questions in relating to pet trust before I hand this off?
You have to have one for each individual animal?
Nope. You can have it for different animals. It does make it a little bit more complicated because say you have $10,000 in the pet trust for a dog, and then in that same trust is for the bird. How do you keep the funds separate? How do you proportion that out? You may have calculated it perfectly. However, the person who's handling it isn't thinking like that. They're like, oh, this expense is coming up, so I need to take care of it next. So it's really thinking about those small little things that affect the bigger picture for their life, but it's just taking care of a friend that's been a friend for your life. So it is nice. And then with that, we have the Secure Act. So Ryan's gonna take this one over. You guys are gonna have so much fun.
I hope you sense sarcasm.
All seriousness.
Okay. How many of you have heard about the Secure Act? Because there's two people who have not, and how it deals with your IRAs and other qualified assets. Okay. How many of you feel like you understand the Secure Act? Darn, I was going to hope someone help teach this today. Okay, here's the thing about the Secure Act. Let's do a little bit of history of qualified assets. This is your 401k, 403, traditional IRAs. For all of those, no income tax has been paid. During your lifetime, at the time you retire and then you get to a certain age, and that varies, then you have to start taking out RMDs, required minimum distributions. That's fine for as long as you're alive. But what happens if you die and there's still money there? In the past, you were able to put a spouse, if you're married, as the next beneficiary, and then your spouse could treat it as your own, and the spouse could take it out over their whole lifetime. That has not changed. The issue is, what if you don't have a surviving spouse? What if you wanted to go down to other beneficiaries, whether it be siblings, nieces and nephews, and specifically kids? It used to be that if you put it to another individual, not even a spouse, they have a life expectancy. They had to start taking it out right after you died, but it could be the rest of your life. But because it was an IRA, it was protected from their creditors and their predators. You could not add to it, but you had to start taking it out based on your life expectancy. Well, that was really good. You also used to be able to say, I will put it into my living trust if I had one as the beneficiary, because maybe my child has died, it goes to a grandchild, and they're too young to get that kind of money. Or they're dysfunctional. Now, these are not your kids. These are your brothers and sisters' kids. Okay, just so you know, and your friends' kids, not yours. But if they're dealing with drugs and alcohol or other things, or they're being influenced, or they don't even know how to manage money, you do not want them to get it outright. So it used to be, if you have a living trust or a will with the testamentary trust, you could put it toward that. Again, it's based on their life expectancy. And again, it was protected from creditors. Then they started toying with it and playing it around with it. And for a while, they said, oh, well, let's not let the kids do it for their life expectancy, but you can still put it to a trust. Well, people fought that, so they came back with, well, let's let the kids do it for their life expectancy, but we won't let it be for a trust. Then they fought about that. So eventually they came up and said, I'll tell you what, we'll let them still roll it over for their life, but they no longer get creditor protection. So if they get sued, child support, bad business deal, bad car accident, and get sued, that IRA is open to that lawsuit, which would mean they may have to cash it out, pay the tax, and whatever's left over goes toward whatever that bill is. Well, that was not very happy to anybody, and before they could fight that out, up comes the Secure Act. Now remember, of the Secure Act, there is the Secure Act, there is the Secure Act 2.0, and Secure Act 2.1. We're at 2.1. Bottom line now is, not only do you not have creditor protection, but if you leave your IRA to your child, traditional IRA, not Roth, traditional IRA, to a child or another person, not spouse, they're limited now to 10 years. And there was the debate about whether or not you could just leave it in the full 10 years. At the end of the 10 years, take the whole thing out, pay the tax on it. Sound good. Well, they came out and clarified, said, no, 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 no. You have to do 110, 19, 18, 17 for the full 10 years. And every time you take something out, then you have to pay the tax on it. Now, those that crunched the numbers before they clarified, we had a bar association dinner downtown, and one of those actuary people that does numbers and all that, they did a case scenario of what happens if a person took the whole amount out, invested it in the stock market for 10 years, how much would they have? If they took 110, 19, 18, 17 for all 10 years, but what they took out and paid taxes, the rest went into that. And what if they just waited for the full 10 years, then took it out, paid the taxes and the penalty? How much would they have? Understanding consistent interest rate and understanding that, of course, you would leave it invested. The number was almost identical. Blew everybody's mind. It was hilarious. But they clarified in the Secure Act and said, no, 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 no. You have to do it 110, 19, 18, 17. And therefore, what you take out every year is added to your income tax. Do some people still cash it out immediately and pay the penalties and interest? Yes. Do some people hold on to it for the full 10 years and at the end of the 10 years take it out, pay the interest and the penalties? Yes. Whatever your situation is should be reviewed with your CPA and your wealth advisor. But the gist of it being that it is to go that way. Now, what if you have minor children? Or you want to go to your minor grandchildren? In that case, it does stay as an IRA till they're 21. But at 21, they now have to start taking it out 110, 19, 18, 17 until they're 30. The exceptions are a child who has special needs or government assistance is the main exception. There's other minor ones, but that's the main one. You may have a child of any age who is on Medicaid and government assistance. There are other rules that apply. So you have to be a little cautious and look at it. Well, what if they're not minors? What if they just really don't know how to handle money? What if they spend every dime they get? And in your personal trust, you're saying for your kids, it's until they're 60. Let it be for their retirement. In that case, you want to put it to your trust. But if you do the laws change? Yes. Now they say it has to come out in only 5 years, and you pay the income tax. So what happens if you have a situation, and many of you are actually, I know we've talked, you've heard my example of my sons, and by the way, if yours are younger, they become 35 and 32 before you blink. And so for my oldest son, every dime he gets, he spends either on our grandson and his hockey or their team, or his animals. Okay, why am I giving him my IRA? If he does that, it's going to be gone. So we have his trust held for his lifetime. We want to make sure there's something for Caden. So for him, we had to make a choice. What is the best income tax protection, or what is the best beneficiary protection? And every individual needs to go through that. You need to be consulting with your financial planner, CPA, and estate planning attorney. Okay? What if you have a very high net worth IRA? Everybody defines that differently. You have 3 kids. You want to leave your IRA equally to the 3 kids until you find out that one of your kids is doing really, really well financially. And if you give this IRA to them, this whole millionaire tax they're fighting over in Washington, it's going to put her over. There'll be a 50% income tax on that money if she inherits your IRA. What are they doing? Their first option was the traditional IRA will go to the other 2, and then they're going to update their distribution provision, and of other assets not in the traditional IRA, balance out the accounts. Because they want to treat the kids good, but they don't want to give a huge income tax burden to one of them over the other one. So in looking at your distributions, it's important to factor some of these things in. It is always back to your goals, your desires, your beneficiaries. But there's another tool that this couple's trying, and that's converting their IRA, traditional, to a Roth. Again, if you're ever going to do that, talk to your financial planner, talk to your CPA. There are different consequences for doing that. But in their case, the couple is already, because of inheritances, over the state of Washington estate tax limit. Yes, if they cash that IRA in and convert it to a traditional or to a Roth IRA, they will have huge income tax, and they will have potentially some penalties, they're not sure. That will result in a considerable amount of money paying to the IRS now. But what did that just do? It let them balance out the Roth between the 3 of them, and it reduced their estate for estate tax purposes because they'd already paid the tax. Again, the creativity comes from working with your whole team. Okay? So that's, in a nutshell, why everybody is frustrated with the Secure Act. And everybody is certain that the Department of Revenue will not change it again. They have promised when they did Secure Act 1, they wouldn't change it again. Remember, we're at 2.1 now, okay? So any questions about that part of it before I head into Roth IRAs? Please.
On the three options you said people originally could do, the third was to take it, wait and do nothing until the end of the 10 years,
Yes.
including all the penalties that build up for not taking your IRA, which are like 25% a year.
Keep going.
You let all that build up and you still end up the same?
Okay. His question was, remember at the very beginning, I used an example of 3 different ways to handle the IRA. The third was keep the IRA for the full 10 years, then take it all out at once and just pay the tax on it at that time. Remember what I said? That was when they first came out with the Secure Act. Guess what they put in 2.1? If you do it for 10 years, now there's a penalty on it. It wasn't on there when they first did the numbers.
Well, it wasn't on there like if you don't do it, if you don't take an RMD now.
They didn't put that in the original
It
one.
wasn't in there.
No.
Okay.
So people just said, we don't have to do it. There's no reason not to. Let's keep it. And the problem, okay, squirrel. The problem was people were already doing that before Secure Act 2.0 came out, and it already missed the first 2 or 3 years.
Yeah.
So the question was the IRS going to go back and penalty them backwards for it? That was a huge debate. They lost, the IRS lost. But really, you didn't tell us and now you're going to penalize us? Well, that is par for the course. But, so yeah, that was not in the original factoring. Okay? Other questions on the traditional? Roth IRAs. Oh, sorry. No, good.
So they don't have a choice anymore. They have to do 1/10, 1/9, 1/8.
You always have a choice, but you will pay penalties and interest if you don't. And I don't know, it's an interesting question. If you take all of it once, I know you have to pay all of the interest at that time. I don't recall them saying if there's a penalty if you take more. Because remember, the RMD is just the required minimum. On most IRAs, you can take more. At some point in time, it just bumps you into the next tax bracket. But yes, all of it is due as ordinary income the year you take it out, which check your tax bracket. But some people who had huge losses take a much larger amount in a given year to offset the losses. Is there a part 2 to that question? Okay.
How does this Secure Act different from what we had before?
The fact that a beneficiary can no longer do it for their lifetime. If I die and my kid's 50 and he can take it out from there all the way to 90 versus 10 years, it stretches out. If it's $1 million IRA, nice problem, but if it's $1 million IRA, that's $100,000 of ordinary income every year. If I take it over 50 years, it's $5,000. Whatever the growth will affect that, but yes, changes it dramatically.
So you have to take it within 10 years.
Yep.
That's the change.
Down, non-spousal, but down. Yep, and ugly. And still no creditor protection either. That did not come back in. So, yes,
How does this compare to like Idaho or Oregon?
that's federal. This is federal. This is not Washington State. Yep. Any state, when it deals with that, it's just the tax rate you have over there will be different.
Because it's a federal thing.
Yeah, it has to be taken out. It's a federal thing that it has to be taken out. Yep. Okay, let's go to the Roth IRA. Remember, the difference, as people try to say, is a traditional IRA is tax deferred. A Roth IRA is tax avoidance. You had a traditional IRA, you converted it to a Roth, you paid the income tax, now that Roth is still going to grow. As it grows, all of that income does not get taxed when you take it out, just to stay there. Good, no problem. How does the Secure Act affect that? The Secure Act said, yeah, you can still keep a tax avoidance only for 10 years. They still limited the Roth IRA to 10 years. And they took it another step. If you made your trust the beneficiary, it is also like a traditional IRA. You still can only do it in 5 years. Here's the thing about the issue of making a trust a beneficiary is you have to remember, check and look at what the tax rate that beneficiary has, because they are only allowed to do it in 5 years. If it's a traditional or a Roth, it has to come out at that time. Because one, either the IRS wants the tax on it, they want their money. It's not like they're rolling in dough, they're broke. And two, they want to make sure that if it's been tax avoided, that stops. You can't keep doing that for a maximum of 5 or 10 years, and then it has to come back into circulation to where they can tax it again. Bottom line, they want to tax it sooner. Okay, so that's how they've affected the...
Make sure I understand correctly. So let's say you do a Roth conversion. It's only good for 10 years.
No. I have to kill you off. You do your Roth conversion and then you die, your beneficiary only has 10 years. But if, like my sons, trust for life, for them, if I put it into the trust, I still have to take it all out, and thereafter everything it earns will have tax on it.
Is there a cost basis to it, or are they looking at the whole amount?
Which part? In a traditional...
Roth.
No, Roth, once you have converted it and you paid your income tax on it, that remaining amount and everything it grows to is tax avoidance. There are other
But if it,
tricks.
after the 5 years,
Then it starts to grow. Everything that grows after that 5 years, that has tax on it.
oh, okay.
So that's the bottom line, for the beneficiary, they get your Roth IRA, and then after 5 years, they're gonna be taxed on the growth?
No. The growth, let me put numbers to it. If I had a $100,000 Roth IRA, and during my lifetime it grew to $120,000, I die, it goes to my boys. I'll get rid of him, my son. He now has a $120,000 Roth IRA that in the next 5 years has to no longer be a Roth. So now let's say it's $130,000. When he takes that out at $130,000, there's no income tax owing on any of it because it was a Roth IRA. But what the IRS wants is they want that $130,000 back in circulation, so everything it earns thereafter has income tax on it. They're trying to get the money back to where they can tax.
So the 130,000 is not taxed, but
Correct.
anything beyond that after 5 years?
Yes.
Before 5 years, no, after 5 years, yes.
Yes, if it's to your trust. If it's to them individually, then they still have the 10 years.
Oh, 10 years
Yeah.
of it.
Yeah, it can grow for a full 10 years without having to take it out. Yes, please.
Two questions. For the Roth IRA, if both myself and my wife pass away, my kid inherit my Roth IRA, and he have to have taken everything out in 10 years.
Yes, the question is for a Roth IRA, if I kill both of you off, provided you still like her and you gave it to her first, so then you're both dead and your son inherits, he can let it stay as a Roth IRA and continue to grow for up to 10 years. But after that, no choice.
No choice, okay? You gotta take it out, or
And he takes it out as principal. There's no tax on it. It was a Roth IRA. But therefore, after that, whatever he invests it in, that he has to pay tax on.
second question, if I put my retirement account into a trust, the trust have to rename my retirement account to the trust name.
Okay, may I pause for just a minute? The question was, can you put your Roth IRA, can you put a traditional 401k retirement plan into your trust? You cannot.
You cannot.
It will have to stay in your name as your Social Security number.
Okay.
After you die, you can make the beneficiary your wife, you can make the beneficiary your trust.
Okay. So you don't recommend put traditional IRA into a trust?
It does not go in the name of a trust. Now, may I pick on you guys? Good. This is your second marriage. You have 3 kids, you have 3. Brady Bunch. And you want to make sure that you get the benefit of his IRA, but if he makes you the beneficiary, you get to get the next beneficiary. You get to choose who gets it next. So we have had some situations where the spouse who had the retirement account made the trust for their wife the beneficiary and put in special wording that the income does not all go outright to her in the next 5 years. It really messes with the IRS's mind because you wanted to make sure any principal would stay in the trust for her benefit for her lifetime and then back to your kids. It is much better now because of the Secure Act to do that with a Roth IRA than a traditional IRA. Because the traditional IRA, they will say, no, to get the tax avoidance for you, she has to get the income. It's all income. I'm making a benefit to my trust to avoid that problem. And they get freaked out. Yep. Other questions? Okay. I'll be back at the end for other questions. We've got some things we're going to look at. And now you get the privilege of listening to Michael.
Perfect. All right. Thanks for your patience, everybody. So a lot of good information so far. Who's learned something already? Good. Lots of hands. Love that. That takes some pressure off of me. You've already learned something, so now I have lower stakes. But I want to talk about some real-world considerations where estate planning sometimes covers topics that you may not have originally thought about. Oftentimes when we're doing estate planning, we're talking about our will or our trust, we're thinking about best-case scenarios. I'm going to have tons of money that I'm going to pass on to my family. Great. I hope you do. That would be wonderful. But sometimes we have other situations where we need to kind of get into topics that may be a little messier. And so one of the ones that we'll start off with here today is drug and alcohol provisions. Now, I've been doing estate planning work for nearly 20 years. And early in my career, I'd have folks come in and talk to me, and they would say, I don't want to leave anything to Jimmy, my son. Okay, well, that's your right. You can choose to leave things to whomever you want for whatever reason or not. But out of curiosity, what's wrong with Jimmy? Why aren't we including him? Jimmy's a drunk. Okay. And I just don't want him using any money I leave him to go on a bender. I think he's going to harm himself if I gave him this money. He just can't manage it. It's going to go right to his vice. Okay, well, let's talk about some of your other options. We can plan around that. And that's why when you meet with attorneys, we have attorney-client confidentiality. We want you to feel welcome and safe in your space to be able to talk to us about what is going on around you with honesty, with openness, because the more that we know, the more options we can introduce to you to show you that there may be another way that you haven't thought of before. So oftentimes when we come across someone who has drug or alcohol problems, we talk about using a trust, a way of not putting that money directly into that person's hands that we're worried about. We don't want to fuel their next bender or put them in harm's way by having them have total control over it. But we also still want to leave something to them so that they can benefit from it in some way. So really, this whole part of our discussion is going to be talking about what kind of safeguards can we put around an individual with some known issues or some known concerns. So we talk about putting together a trust. We're going to have someone manage that trust. So Jimmy might be the beneficiary of it. The money can be used for Jimmy's benefit, but we need to have someone else who's going to oversee it to make sure that Jimmy's on the straight and narrow, that he's keeping sober, or that he's seeking treatment or getting help in some way. And you get to play a leading role in defining what that looks like. What are your concerns with regards to the individual? What would you like to see done? So for example, people will put in terms and conditions to say, I want to make sure that they are on the straight and narrow. I want to make sure that they are passing a urinalysis test every so often, and they'll set a timeline. I want to make sure that they've undergone treatment. The trust money can even pay for that treatment. So it's being used for Jimmy's benefit. But if he wants to get anything more from it, He's really got to make sure that he is being disciplined and getting the help he needs, getting the support he needs, and has turned his life around. Do we know, can we guarantee that Jimmy's going to go on that path? We cannot, unfortunately. Many times the disease that we're talking about here in terms of addiction is a real struggle for a lot of folks. But we're trying everything we can to put them onto that best path. Sometimes you may have provisions inside that trust where we're looking after Jimmy because we were going to make sure that he's got a roof over his head. We can pay rent to somebody to make sure he's got a place to live. But if he wants any additional expenditures, he's got to meet other terms and conditions. So a lot of this can be very fluid depending on what your situation is, the person that you're trying to help, what their particular needs might be, and just how much assistance do you want to provide. So all of this can be, there's no one way to do this, I guess is the short way of putting all of that. We want to make sure we're doing it circumstance by circumstance. I'm sorry?
Family member?
The question is whether this is for a family member. Yeah, oftentimes it is. But when you're doing your estate plan, you get to pick and choose who you want to benefit from your estate. So you could be putting these provisions in place for a good friend of your family, a neighbor of yours, a colleague of yours, depending on whom you'd like to support. And then oftentimes, I get the question of, is it going to be a family member who manages the trust for Jimmy? And that's also a really good question. That turns into a little bit of a question of, do I want to be my brother's keeper? Do I want to be the one that has to make these decisions? And that's also going to be a personal examination to determine what is the relationship between the trustee who's managing the money and Jimmy, who needs the benefit of it. Do they get along? Is one an enabler? Will one actually be able to hold to the terms and conditions that you've laid out to make sure that Jimmy gets the help he needs? All of those would be important factors to take into consideration when examining the people that you want to put in place. So, excellent question. Other questions on sort of some of these drug or alcohol provisions? I'm not going to pry too much here. You don't need to disclose if you have any of those in your situation. That's better suited for a conversation or appointment with us. So if anyone has questions afterwards, talk to our admin team here and get scheduled with one of us here to talk about that in more depth. Now, this is the one that we tend to get a lot of questions about. We have a whole slew of considerations that we take into effect here when we have marriage issues. And this can take many different forms. The first scenario I want you to envision is you are setting up your estate plan, you're leaving money or assets to your children. Now, your children are great, level-headed, perfect, just like Ryan was saying. Your kids are great. It's other kids we worry about. But sometimes in this situation, it's their spouse we're worried about. I love my son, I love my daughter, but his or her spouse or partner, maybe that's the one I've got a little bit of concern about. And maybe they're looking down the road and maybe they think, one day, when the old man kicks it, we're gonna get a whole bucket of money and then I'm gonna take what I can and run. And that's where we start to question their motivation. Is this for love? Is this for money? And it's not just the plots of movies and TV shows. It does happen in real life. And we want to provide you with some options and some tools so that you're protecting your kids or whomever you're leaving things to. So what can we do in that situation? Well, we might be leaving things to your children in a trust. It's their separate property. Your children can do whatever they want with the money you've left them. But should their marriage fall apart and there's some future divorce that happens, your child's partner or spouse does not have a claim to that inheritance that you've left them. It's been isolated, it's been segregated, it has remained your child's separate property, not to be divided up in any future divorce or dissolution with their partner or their spouse. Does that make sense? All right, good. I love to see heads nod when we go over some of these topics here. We can also use some provisions regarding marriage when we're talking about our own marriages. I mean, we're putting together plans either for ourselves or with our spouse, and sometimes we're taking into consideration that, well, if I were to pass, I want my wife to be happy, and she might meet someone down the road, and she might remarry. But I also want to make sure that we have two kids, that I want to make sure my 2 kids get taken care of and they're not forgotten in the mix. And so sometimes we'll put special provisions or planning tools into effect to make sure that I have earmarked money in a trust that my wife will benefit from for her lifetime, but any money left over will go down to my kids, and she doesn't get to change that. Even if she gets remarried, she cannot interfere with my goals and my objectives with the remaining money in that trust. So I can still exert a little bit of control. I still want to have my say as to what's going to happen with my portion of our estate. And so if that's a situation that you might be thinking about or fall into, rest assured you have some tools available to you to kind of maintain that element of control and be able to dictate who you want to include in your plan and how. Because at the end of the day, that's really what estate planning is all about. Question?
Having a trust to pass down like that is just a cleaner way of what your children could do on themselves, isn't it? I mean, they could take the money they inherit and establish their own trust, right?
That's a great question. So the question is, if we're setting this up for them, that may be a cleaner, simpler tool, I think was the wording you used, but your children could ultimately do some of this for themselves. The answer is yes. Sometimes they can do this for themselves if they're aware of it, if they have the forethought of doing it. But that includes a little bit of risk as well. If we leave it to our kids to take an inheritance and immediately put it into a separate property account and manage it and never commingle it with their spouse's funds, they may reach the same conclusion or reach the same outcome that we're trying to set up for them. But the risk is they don't. Or the risk is they're using this money and they're paying household bills from it and it's being commingled and the accounting on it is not clear. And now we've muddied the waters that if they ever did get divorced, a good divorce attorney is going to come in and argue, well, it may have started as an inheritance, but it ended up as joint money that they used for common household expenses and now it's commingled. And so we've lost the ability to ensure that outcome. Yeah, great question though.
So
Yes.
are you saying that if, when it goes down to your children, you put it in a separate trust for them, that keeps all this other stuff that avoids all these other problems?
Yeah, that's the intent behind it. So the question was, when we're using this trust for our kids, the trust is helping to offer that protection from these outside risks that we've been discussing, like commingling of funds. Yes, it is a huge step to ensure that we're getting that kind of an outcome. Absolutely.
Even if you work with them to establish a trust before you pass away, and if they are the trustee of their trust, and there's another category where they can't change it while they're living, I think they can, if it's their trust and they set it up, when they get the money after you're gone, if that's the way it's supposed to work, then they're the trustee and they can do whatever they please with it.
Okay, let's make sure this was an excellent point. Let's make sure the whole room could hear you on this one. The comment was, if we're leaving money in a trust for our children, but we make that child the trustee of their own trust, couldn't they just end up doing what they want with it anyway? And maybe they withdraw money and they're commingling it then and we lose the protection that we've been trying to set things up? That is absolutely a risk. Because you're right, if they are the trustee of their own trust, they could end up just withdrawing all of it unless you have certain safeguards or restrictions on that. But the intent is there to set them on the right foot, and education and discussions within your family to make sure they understand sort of why this is being done, the benefit that it may offer them, goes a long way so that they start to actually follow through on what we hope they will do. But sometimes we can't protect them from themselves from beyond the grave if they're going to be given control. If we're fearful that they may not be capable of managing it for themselves, maybe that turns into a conversation about who might be a better trustee to manage that for them so that they don't inadvertently do something that's going to cause problems or leave things open to losing those funds in a divorce or put that money at risk.
So, question to further refine on a trust. You have a trust set up for tax purposes. You take out a certain amount of income out of that trust every year so that you are getting taxed as income instead of trust tax. That money is going to be used by that trustee holder for, whatever it is, paying the mortgage, paying for the kids' education or whatever. So it's come out of the trust, it's being used, you're being taxed as income, just regular income. Are you saying that if, like a divorce happened, that just because you've taken money out of that trust and then used it outside the trust, that now you've got a pathway back into the trust?
That's a great.
And that trust has been held in the trustee names, the spouse doesn't have control of it, all of that is tight.
Yes, good question. So I would kind of rephrase it and summarize it. Correct me if I've gotten anything wrong here. The concern being expressed here is if we've got this separate property trust and money is coming out of it on a regular basis and it's being used for certain expenditures that may benefit the community, does that now put that whole trust at risk? And the answer is no, because those funds that are still in the trust are still separate and distinct from the community. So when the money comes out of the trust, it can be used however the trustee wishes it to be used. But it still has earmarked the remaining funds are separate and distinct from the trustee or from the beneficiary. So that's a very important distinction. Thank you for asking that question to help clarify that. Yes, sir.
If we put a provision in a trust, putting our kid to get the money to avoid this, in case there's a divorce, avoid the spouse from taking money. Do the provision or the funding have to be in that trust to do that? Then if I don't have any funding there to get the kid.
Yeah, so the question is about funding these trusts for the children in order to help protect it in the event of a dissolution or a divorce. I think if I'm hearing your question correctly, the question is when does it get funded?
Right.
Yeah, so oftentimes we will have these trusts only get funded after something has happened to us, or if you're married, something has happened to both of the spouses. Okay. Whatever funds are in the estate at that point before they get passed down to that child, they're going to go into the trust instead. And so it's all going to happen later on after you're gone. Yeah, thank you for asking that. Good, great questions, guys. Well done.
I've got 6 siblings, and so when we went through this, it was difficult.
It can be.
It was difficult.
Yeah. Was that in a will or a trust?
I think it was a will.
Yeah. Yeah, so the comment here was with 6 siblings having gone through this, they encountered some difficulties here. And yeah, the players involved and the number of people that we have things going to can make an impact. But there's ways to address it to try to keep it streamlined. I think the more clarity that you build into the document as to what your vision is, as to how you want things to end up, gives additional support and guidance to the trustee or to the personal representative of a will, that they know they're doing the right thing because you've told them exactly how it's supposed to happen. You really haven't given them any leeway or discretion to mess it up along the way. They have to follow your guidance here. All right. Well, I think we've covered a lot of these marriage considerations here. I'll just touch on a couple of points here that are on the slide. Sometimes we'll see a lot of these things come up more often in high net worth families where there's more dollars at stake. That's usually where we see a little bit more concern that the marriages or the relationships that people get into are maybe not purely out of love, that they may have an ulterior motive. Naturally, I think that's kind of an instinctual thing that we might realize, that puts a bigger target on someone's back. And that also just kind of helps to make sure that when we do these kinds of provisions and we're looking to benefit our family, our child, our bloodline, the law presumes that we're taking care of our bloodline first, that we don't have default provisions that say, oh, if my child passes, it's going to go to their spouse. I get that question all the time, and that's not correct. The child's spouse, your son or your daughter-in-law, has no right to your estate. They're not a blood relative of yours. And so we put a lot of preference in our state laws on making sure that we're looking at your direct bloodline relations here. So hopefully that puts that mind at ease, anyone who's wondering about that piece. But also we can include provisions that if you do want to benefit your child's spouse, we'll look at the flip side of this conversation for a moment. You love your son-in-law, your daughter-in-law. Maybe you love them even more than your own child because they're got a better head on their shoulders. They're the better half in the relationship. You can always include them in your plan. It's always your choice as to how to include somebody, who to include, and how you want to take care of them. And I have clients all the time who will say, yeah, I actually have grown to like them more. They're easier to talk to. They're the more responsible one. And so that's not uncommon either. All right, let's, the other major topic that we usually get an opportunity to talk about here is disinheritance. And that means I do not want anybody in this category to receive my estate. I don't want this individual, I don't want this branch of the family, I don't want that black sheep of the family to receive anything from me. And like I said earlier, that's your choice. You absolutely can include whomever you want, and by that same rule, you can exclude anybody that you want. Okay? So, whatever reason you have for it, we'll probably ask a few questions just so we better understand what we're getting into. Because if we know the motivation behind it or the root cause behind it, it helps us put you in a better situation to make sure that that outcome is exactly what's going to happen. So don't be surprised if we ask some follow-up questions. Okay? It's not us being nosy. We just want to make sure we're protecting you and your plan the way you want. Yes?
Quick question. We don't have kids.
Okay.
And I've got 2 siblings. And they're both well off. So we don't plan on giving any of the family any money. So in that case, should we put a disinheritance clause in our will or whatever to make sure they don't come back after we're dead and say, we're relatives, this money is ours?
Great question. All right, so to make sure everybody in the back heard that as well, you may find yourself in a situation where you may have family members that you don't want included. This hypothetical here was we don't have kids, we have siblings who might receive something from us, but we don't want to include them, they're doing just fine. Instead, we have a different plan for our estate. So the question then becomes, do we need to specifically say something in the will that I don't want my brother or my sister to receive this, instead I want it going here? The answer is probably. We probably will include something like that. So I'll back up and kind of explain that answer in a little bit more context. The state of Washington has a plan for each of you when it comes to who to leave your estate to. We have a default set of rules. We call it the laws of intestacy, meaning if someone passed away, they didn't have an estate plan, no will, no trust in place, the state of Washington tells us who it's going to go to. And it goes through a series of relationships. We first look to see, well, are you married? It's going to go to your spouse. If not, do you have kids? It's going to go to your kids. If you've got grandkids, it keeps going down the bloodline. Then we start working up. Well, if you don't have any of those people in your relationships or in your life, we then go to see, well, are your parents still with us? Do you have siblings? Do you have nieces and nephews? Do you have grandparents? Do you have aunts and uncles? Do you have cousins? We keep going through the family tree systematically until we find someone who would receive your estate. So the reason I go through that exercise to kind of show you that background is if you had a family member, in this case a sibling, who could come and say, well, if there was no plan, I would have gotten everything. I should have gotten everything. Why didn't I get everything? That is usually fuel to their fire and the basis of a claim as to why they think they should get something. So the best defense against that is to say, I considered that, and I specifically do not choose to leave anything to these people. Instead, I'm leaving it here. And so again, Estate planning is entirely built around what your goals, what your objectives are. The state courts go to extensive lengths to make sure that we honor your intentions. So the better we can articulate them and document them, the stronger your plan is. Now, the next question I typically get after that is, well, it's not like I'm excluding them because I don't love them or anything. And so sometimes we soften the blow with the language we might use. It's not for any lack of love or affection. It's just they're doing fine. We're going to instead do this over here instead. And so we can always address those types of concerns if that happens to be among them. Thank you for that. That was a great touching off point here. And that kind of goes to the clear communication of what are we trying to do inside the document as well as amongst family members too. If you were to talk to your siblings and say, hey, you guys are doing great right now. I think that I might be able to leave a bigger impact in the world if I did this other thing instead. Well, if they know that they're not counting on those chickens to hatch one day for themselves and that they're not going to get an inheritance from you, maybe that will help reset expectations and that they won't be caught off guard or surprised that, wait a second, I thought I was going to get the whole farm. No, not this time. So really the whole point here is making sure that what we know is what your goals are, who we're including, who we're excluding. We figure out how to phrase it in a way that's going to offer your documentation the best strength possible. Now, one of my favorite parts of this disinheritance planning here is the clause that someone will read one day where it's like, if you bring a challenge and you stir the pot and you cause trouble for anybody in this document, you automatically now get nothing. Or you might get $1. You know, there's things like that that really kind of, oh gosh, they really mean business here. So you'll see terminology like that frequently when you look at these types of documents. Fantastic. Before I switch topics here on you, any other questions on disinheritance? I think we covered that one pretty well. All right, so this is another fun area. We touched upon sort of the idea of divorces that might happen within the family, typically for our kids or other relatives. But the odds are these days, 1 out of every 2 marriages ends in a divorce. So it's a topic we should at least address and put some information out there so the more you know, the better you can plan. This section of the topic is called, Does My Divorce Decree Automatically Update My Estate Plan? And I'm going to give you the typical lawyer answer. It depends, right? So let's dive into some of the nuance here. First of all, when in the process of a divorce does the divorce decree come into the picture? Does that happen right away when we file for divorce? No. The divorce decree is that end stage. After all the battles are fought, after all the wars are waged, and the court finally signs off on something that says, okay, you guys are finally divorced. Now, the fastest that can possibly happen in Washington State is 90 days from the filing date of a divorce. We have a mandatory 90-day waiting period before a divorce can be issued. So for 90 days, we live in limbo before that divorce decree gets entered at a minimum. So the divorce decree will oftentimes spell out very clearly who gets custody of the kids, what's the visitation schedule, who owes child support, how much, how is it to be paid. And it will also talk about different assets. You get to keep this. These are your assets, these are your debts. These are your assets, these are your debts. So the divorce decree is trying to bring finality to a situation where the marriage has ended. Now, I told you how Washington State has laws that are here designed to tell us who gets what if you never got around to doing your own will or your own trust. It kind of fills in the gaps and makes certain assumptions. Well, Washington law also makes certain assumptions when there is a divorce decree. Most times people do not want their former spouse to now get anything from their estate plan. So that's not always, but that is the presumption that the state has made. And so we have laws that say when the divorce decree is entered, if your spouse was named to receive something in your will or in your trust, they won't get it anymore. Instead, we're going to treat that ex-spouse as if they passed away the very date that that divorce decree entered. And so most people rejoice when they hear that. Well, good, I don't want them to get that piece of anything anyway. The same rule applies if your spouse was named to be a person handling the estate as your executor, your personal representative, your trustee. The law will now presume you didn't want that outcome anymore. And so automatically, if they're in that document, they don't have any authority to continue on in that role. Now, every now and then I'll have a person come in and say, I wanted to put together a will, I want to put together a trust, I'm single now, but I want to leave everything to my ex-spouse. Oh, okay. And I want my ex-spouse to make all the decisions. We determined that we couldn't be married anymore, but she's actually my best friend in the whole world, and we get along fine now that the marriage is over. Okay, whatever works. In that situation, we now have to take steps that undoes the presumption that Washington State has for you. So you have to do a brand new will or new trust after the date of the divorce decree in order to say, no, I know what the outcome would normally be, but I really do want to include this person. And that's your choice, and you can. But that's just sort of an extra step to be aware of here. Questions on that so far? No? Okay.
Are we running out of people that will handle the state, the executor, whatever? Seems like you have to really be qualified to
Yeah.
take that spot.
The comment here was, are we running out of people who might be good fit to be responsible for this as the executor or the trustee? What are the qualifications that we need to keep in mind? Excellent question. So really the choice of who you want to put in charge of this is your choice. And we typically say, well, who are the folks in your world that you trust the most? Who's level-headed, who's responsible, who can make decisions under pressure, follow rules, and just be generally a good person to handle this. And then we try to steer you towards different tiers of relationships. We go, is there anybody immediately in the family? Is that my spouse? Is that my kids? If they're not immediately in the family, we extend it. Are there siblings that I have, or a niece or a nephew who happens to be really sharp and might be a good candidate to take on those responsibilities? If we still don't have people at that stages of relationship, we go to another tier. We go, well, who else is in your circle? Do you have friends or neighbors or folks you know from church or people you used to work with? Who are the other people that you know that you have confidence in? And if we still are striking out on that, can we find a professional who can step in and help me make sure all of these outcomes I want are achieved? And that's where you can hire a professional trust company, or our law firm can serve as a trustee or a fiduciary in those situations as well. So we'll always work with you to find who the appropriate people are. And we generally try to have a rule of 3. Who's your top choice? And can we get a couple of backups in there as well, just to kind of future-proof your document as best we can? Yeah, great question. Thank you. All right. Going back to our conversation on the divorce decree. So what happens before that decree is entered? We have this period of limbo I talked about where we're not getting along, but we're not technically divorced yet. If your will says it goes to your spouse, well, guess what? You're still technically married during that period of time. If you passed away during that interim period, it would be your spouse who gets that. So we frequently will have this conversation, and someone calls the office and says, yeah, there has been a filing for divorce. What do I do? Well, let's talk. What is the outcome you want? Because if we don't want the soon-to-be ex to be in charge of this or to receive anything, we should do an update. We don't want to rely on the benefits of that state law because we can't assure, no tomorrow is guaranteed. We want to make sure that you are taking as much control in the process as you can to get the outcome that you want. And so that is something that we definitely encourage people to be aware of, that there is that period of time before a divorce decree is entered and finalized that you may be at risk of not having the outcome that you want. There's one slight difference here I also want to highlight when you have powers of attorney in place. Usually we have encouraged folks to have a power of attorney for financial matters, someone who can step in your shoes and make sure your bills are being paid and manage your finances if you ever became incapacitated. We also encourage people to have a durable power of attorney for healthcare decisions, someone who can advocate for you and speak with your physicians to make sure you're getting appropriate care during any period of incapacity. Well, when we put these plans together and we're married, who often are we listing as our top choice to manage all of that for us? It's usually our spouse. And so the state law, using these same assumptions goes, well, if someone's already filed for a dissolution or a divorce, they're probably not the best person to be making these kinds of decisions. And so although the will doesn't change until the divorce decree is entered, these other power of attorney documents will invalidate that authority to the spouse upon filing for a dissolution. And so that's a slight difference there. I just wanted to call that out and make sure that you're aware of that. So that can kind of give you a little bit of protection here, because again, state law is just assuming certain things based on what most people would want to happen in those situations, those outcomes here. Another interesting part of the world of divorce. I've never really handled divorces directly, but I've worked in offices and spent a lot of time with divorce attorneys, so you hear all the horror stories. The other horror stories that are out there come along in terms of your beneficiary designations on different financial accounts. So those financial accounts with a beneficiary, like your bank account, your IRA, your 401k, those beneficiary designations mean those assets are not necessarily controlled by your trust or by your will. So it's important to pay attention to what those designations say. And if you're in the middle of a divorce and it's just started, it's not uncommon for there to be some kind of a protection order entered to say both parties are restrained from making any changes to these financial accounts until the divorce decree is entered, because we don't want one of the parties in that failing marriage to go swoop up assets and put them over here and wage war against their soon-to-be ex. So some of those beneficiary designations, you may have to go back and change when the divorce decree is entered to make sure that you are now putting things where they're supposed to be. Your divorce decree could also tell you, mandate, that this life insurance policy remain in effect for the benefit of your spouse or your kids. And so you're going to have to comply with that order when you go and clean up those designations to make sure that you're doing what the court has ordered you to do. So there's lots of layers to this, but this is just sort of give you an overview of basically, if you find yourself in a situation or you know someone who's going through a divorce, please encourage them to reach out to their estate planning attorney. If they don't have one, call us. Because we'll talk them through what steps to take and what to be aware of and what to be looking out for. Because there's a lot of things that can be happening during this moment of time. And having worked with divorce attorneys before, they assure me that people go temporarily insane during the proceedings for a divorce because they're so worried about the kids, they're worried about how their future is going to be financed, and the security that they thought they had has now been pulled out from underneath them, that they start to go a little crazy and they don't think clearly. Yes, sir.
Question regarding if you have a account that's totally in your name, say a 401k.
Okay.
Can you go in and change the beneficiary on that anytime you want?
So the question here is, if you have an account that's solely in your name, like a 401k was the example, can't you go in and change the beneficiary at any time that you want? And the answer is not necessarily, because if that 401k has been funded with contributions during the course of your marriage, and we're dealing with a potential divorce situation, your spouse has a certain right or certain interest in that 401k because it was funded with wages earned during the marriage, which are community assets. So that can be a little bit of a shock to hear that. Because when you look at the statements, only got my name on it, I thought that was 100% mine, but it's not clearly 100% yours. And that would be something that would be subject to division in a divorce proceeding. So that's something that the judge would weigh in on as to how to apportion that.
Is that something that raises problems, say if you die then, and your wife, still alive, claims that that's part mine, you can't give it to whoever you put as a beneficiary if she wasn't included?
So it all depends on, so the follow-up question was, does that pose a problem if you have this type of an account and you pass away? Could your spouse be making claim to it? And it's all going to depend on what those beneficiaries on that account were set up as. If it was all designated to go to your spouse, then there's no problem. Your spouse will end up receiving it. But if you were trying to designate someone other than your spouse, that company administrating that 401k is usually going to require spousal consent because they recognize that there's a community aspect to that, and your spouse might need to sign off.
At least 50% must go to your spouse, or something like that, when you're doing these beneficiary designations.
Correct. So sometimes your financial company administering these things will set certain parameters or spell out that you can designate up to 50% before you get spousal approval. And that is a reflection on that there is an understanding here that there is a community interest in that you can freely dispose of your half of things, but you can't dispose of your spouse's interest in things unless you get spousal consent. Yeah. Excellent question. Yes, sir.
On his scenario, he have no beneficiary on his 401k. If he pass away, he will have to, someone have to go through probate before the wife get the money.
So the hypothetical here is if we have a 401k that names no beneficiaries, and then there was a mention of a surviving spouse, would we need to go through a probate to figure out who gets to make claim for that money? And that question is oftentimes, the answer is yes. We're going to likely need to go through probate, especially depending on the dollar amounts involved. If the value of that account is over $100,000, probate is almost assured. If it's underneath that amount, there is the possibility of using something called a small estate affidavit to make claim for those funds, but someone's going to have to outline the basis for how they are entitled to it rather than someone else. And without beneficiaries, we're going to look to see what does their will say, what does their trust say. If they don't have any of those documents, then we go to that state law I mentioned earlier, and they're going to have to say, well, based on my relationship, I have a priority to making claim for that. Depending on the dollar amount, but oftentimes, yes. That is a very common part to that. Yeah. Thank you for that. All right. Well, any other questions here before we wrap things up? I want to make sure we have some time for other questions and answers here, but I'm going to leave this slide up here for you guys. There is a way here, if you want to receive newsletters from us, pull out your phone and point it at the screen. You'll get a little link that pops up and you can click on it, and then you put in your email address and you'll get future editions of our newsletter. They go out every month. You can get information sent to you. If you have other questions that you want to make sure you talk to us privately about, feel free to talk to our admin team here on your way out to schedule appointments with any of the three of us here. We're all able to assist you with this. I'm going to stand off to the side so I don't block your picture.
It's also on the newsletter you have in each of your packets. Okay. Yeah, no worries. Okay.
One of the questions that was asked before, we always check to make sure you're at the right seminar, was the issues of will versus trust. So probably grab for some of you, this is a familiar handout. When we meet with the client at their initial meeting or follow-ups, this sheet is given out. It talks about pluses and minuses to wills and trust. The first thing to remember in Washington State is there is no right tool. There is no one size fits all. Everybody does this one. If an attorney tells you that, they're lying. Because the reality is, in Washington State, if you've worked with us, you realize your tool for estate planning should be based on your goals. In some states, California and New York, which are the two worst probate states to do it in those states the fees are so exorbitant that about 80 to 90% of our clients that move up from California all have trusts. My uncle, who's an attorney in Redding, California, could count on two hands how many wills he would do in a whole year, but couldn't how many trusts he did. In Oregon, you do not get non-intervention powers, so it makes it more difficult there. Hawaii, there really is Hawaii time. But I've worked with some Midwest states where they have, I'm going to project.
That's it.
In some Midwest states, I've worked with settling estates where we had property there, but they were from here. It's almost like a handshake. I'll call up an attorney and say, hey, I need this piece of property transferred. We've got to do this and this. Great. When do you want it? I really can't get to it till next week. Would that be okay? I can't get the court to respond to me by next week, and they'll be done. So in Washington, it has to be based on what your goals are. The example I will usually use is the difference between a will and a trust. A will, you create a handbag that the only thing in the handbag during your lifetime is your babysitter instructions of who gets it when you die. But none of your assets are in it. When you die, and there's the probate, that is converting through a court process, which we don't have time to go through probate today, a court process, the handbag into a full suitcase. And in the probate process, after you're dead, we fill up the suitcase with your assets. There's your estate account. And then you carry out the babysitter instructions. That's using a will. For people who don't want to go through probate or have other goals that accomplish it, they're willing to say, I will spend the time and the money now to create the whole suitcase now and to fill the suitcase up. The reason the retirement account went through probate was not only did it not have a beneficiary, it was still in that person's name. Probate occurs because I died, there's something in my name, it didn't go to anybody, and nobody's got control over it. The court sets up a process, probate, to give someone the authority to stand in my shoes. There are attorneys that swear at probates. There are attorneys that swear by probates. That will tell you what they have to sell you. Think of probate as time and money after you die. I was with a client, several $1 million. Kids are each getting $1 million or so. The rest is going to charity. We talked about the fact he was about to retire. He hopes to take a trip. And we talked about the difference between a will and a trust for him. It'd be about $4,000 in his situation. So he says, let me get this straight. I could spend an extra $4,000 right now so that if I died, I make it easier for my kids after I'm dead. Yep. I told you I was retiring, right? Yes, sure did. I got a trip plan. Mentioned that? Yes, you did. You want to guess how much my trip's going to cost me? Well, not being a betting man, if I'm going to guess, I'd say somewhere around $4,000. He goes, almost to the penny. Put this in your notes. I want you to work for your inheritance. I wrote it down. It's still there. When he dies, he still has a will, by the way. When he dies, his kids are going to go, didn't you talk to him about a trust? I sure did. This is what he said. They'll be mad. They can be mad at me. I don't care. Everybody has their own goals. You get to choose. Do you want to spend the time and the money, create the suitcase, fill it up? Do you want to wait until you die? Let someone else deal with it. It's not right or wrong. It's what are your goals? And that's a part of the meetings that we have with our clients. If that's all new to you, schedule that 2-hour meeting. There's no charge for it. We have a lot of fun, except I kill you off the whole time.
Thank you.
Any other questions for us before?
Just wanted to thank everyone for coming. If there are no other questions, people want to announce out to everyone. Each of the attorneys will hang back, so if you have any questions, ask us privately. We're happy to answer them, but if it is a little bit longer, we do have our assistants down here to be able to help book any appointments, set up any phone calls, whatever you need. Alrighty, well, thank you so much for coming.